right. Good afternoon, everyone. I'm Ben Gonzalez with TDI's Communications Office, and thanks for joining us today for our webinar about the Division of Workers' Compensation Dispute Resolution System. We'll be giving you an overview of the entire process from benefit review conferences to contested case hearings and finally appeal panel reviews. You'll learn about DWC's organization and some common issues and disputes that you'll want to avoid. So we're going to have a short presentation first to give you that overview, and then we'll come back here for a live Q&A and take your questions. And a quick note, if you're planning to earn CE credit today, you do have to stay for the whole hour, both the recorded presentation and the Q&A portion. All right, let's get started with our presentation, and we'll see you right back here shortly.
I'm Anna Thornton. I am the Regional Director of Hearings for the Southern and Eastern regions of the Texas Department of Insurance Division of Workers' Compensation.
I'm Jerry Thomas. I'm one of the Regional Directors of Hearings for the Texas Department of Insurance Division of Workers' Compensation, and I handle the Northwestern regions.
I'm Jennifer Hopens. I'm the Deputy Commissioner for the Texas Department of Insurance Division of Workers' Compensation Appeals Panel.
Our presentation is on resolving disputes in the Texas workers' compensation system. Okay, one might ask, what is a dispute or a benefit dispute in the workers' compensation system? What we are seeing here is a definition that is verbatim from 28 Texas Administrative Code, section 140.11. And that definition is a disputed issue arising under the Texas Workers' Compensation Act in a workers' compensation claim regarding compensability or eligibility for or the amount of income or death benefits. And something important for everyone to keep in mind is that most statutes and rules regarding disputes before the Division of Workers' Compensation are found at Section 410 of the Texas Labor Code and also Chapters 140 through 147 of the Texas Administrative Code. And something else that is important to keep in mind is that a benefit dispute is different from a medical fee or medical necessity dispute. On this slide, we are seeing issues that can come up in benefit disputes. And I would say that the first 6 that we are seeing are the most common issues that we will see. This is not an exhaustive list. For example, the issue of lifetime income benefits or average weekly wage. Those are also issues that can come up. This is also a good point to mention that these benefit dispute proceedings do go through the hearings department of the Division of Workers' Compensation. As my colleagues Jerry Thomas and Jennifer Hopens will explain in more detail, I will also explain in more detail as well. Benefit disputes do start with a benefit review conference. Then they can proceed to a contested case hearing. Then after that, they can even further proceed to an appeal before the appeals panel.
All right, I'll be discussing initiating a dispute with plain language notices, or PLNs, and the benefit review conference process. With the benefit review conference process, I will discuss number 1, attempts to resolve a dispute, 2, filing a DWIC 45, 3, benefit review conference exchanges, number 4, the purpose of a BRC, and number 5, the BRC benefit review conference report. So first, with the plain language notice or the PLN. With every PLN or plain language notice, you must explain the reason for the dispute in plain language without unnecessary use of technical terms, acronyms, or abbreviations. We have several types of PLNs or plain language notices. The first is the PLN 1, and that is the Notice of Denial of Compensability, Liability, and Refusal to Pay Benefits. I refer you to 28 Texas Administrative Code, Section 124.2. And the PLN-1 is a notice that must be used by an insurance carrier to notify an injured employee or a beneficiary and the Texas Department of Insurance, Division of Workers' Compensation, of the insurance carrier's denial of compensability or liability for an injury. The second type of PLN or plain language notice is the PLN-11, and it's a notice of disputed issue or issues and refusal to pay benefits. A PLN-11 must be used to notify an injured employee or a beneficiary and the Texas Department of Insurance, Division of Workers' Compensation, of an insurance carrier's dispute of an issue such as disability, extent of injury, or death benefits. So the PLN or plain language notice 1 is to dispute the claim in its entirety, and the PLN or plain language notice 11 is to dispute a particular issue such as disability. The third type of PLN or plain language notice is the PLN-12, and that is a notice of potential entitlement to workers' compensation death benefits. I refer you to 28 Texas Administrative Code, Section 132.17D and F, and an insurance carrier shall send a plain language notice within 7 days of the date they became aware of the identity of a beneficiary and a means of contacting them. This is important because the division is required to send notice of the time, date, and place of any hearings on a claim to the necessary parties. In Appeals Panel Decision 130472, the decision of an administrative law judge was reversed and the entire case was remanded back to the judge to ensure that the next friend and minor beneficiary in a death benefit case received notice of the time, date, and place of the hearing on that case. It's also important with a plain language notice 12, it's important to attach a DWIC 42 to the plain language notice 12. So moving next, after you've initiated the dispute with the plain language notice, is the benefit review conference process. I refer you to Texas Labor Code, Section 410.023B and 28 Texas Administrative Code, Section 141.1D. The first thing to do is to file the DWIC Form 45. Again, request to schedule, reschedule, or cancel a benefit review conference. But prior to doing that, that form includes a place for you to certify and sign that prior to filing the request, you've made reasonable efforts to resolve the disputed issue or issues. That means that the parties are required to talk to each other and attempt to reach a resolution before requesting dispute resolution assistance from DWIC, or the division. It means that the relevant parties should be involved in a discussion of the details and options specific to the individual claim. This means exchanging information or documents and looking for common ground for resolution. So again, in summary, you filed your plain language notice to initiate a dispute, and you have attempted to resolve the dispute with the opposing party. The next step is to file a DWIC Form 45, and that's just a regular 45. It's a request to schedule, reschedule, or cancel a benefit review conference. There is a second type of DWIC 45. It's the DWIC Form 45M, and that's the request to schedule, reschedule, or cancel a benefit review conference to appeal a medical fee dispute decision. When filing any 45, it's important to keep specific timeframes for filing the DWIC Form 45 in the following 4 types of cases. We have 90 days for maximum medical improvement and impairment rating cases, and that's 28 Texas Administrative Code, Section 130.12. Next is 10 days for disputing entitlement to supplemental income benefit cases, and that's 28 Texas Administrative Code, Section 130.108. Third is 10 days to dispute a change of treating doctor, and that's 28 Texas Administrative Code, Section 126.9. And finally, 20 days for filing a DWIC Form 45M to appeal a medical fee dispute decision, and that's 28 Texas Administrative Code, Section 133.307G. So in summary, you've initiated the dispute with the PLN, and you've entered the benefit review conference process. You filed your DWIC 45. The third item to complete is the benefit review conference exchange. Now, parties are required to send and exchange pertinent information. And pertinent information means all information relevant to the resolution of the disputed issue or issues, and that's 28 Texas Administrative Code, Section 141.4. And I highly encourage everybody to read that section. First, you have all pertinent information that must be sent to the opposing party or parties before the request for a benefit review conference is sent to the division. And that's necessary because if we're requiring you to certify that you've reached out to try to resolve the dispute with the opposing party, it makes sense that you have sent them the required information so you're on a level playing field. The second requirement is that the opposing party must send all pertinent information to the requesting party and other parties within 10 working days after receiving a copy of the benefit review conference request. And the final exchange deadline, and this one does involve the division, the previous two did not. The final step is the information must be exchanged with the opposing party or parties and filed with the division at least 14 days before the benefit review conference, or 5 days if the benefit review conference request is expedited. So again, you've initiated the dispute with the PLN process, or the plain language notices. You have attempted to resolve the dispute and entered the benefit review conference process. You've filed your DWIC Form 45, and you've completed your benefit review conference exchange. So now you're ready to sit down and have a benefit review conference. The purpose of the benefit review conference is to sit down with the benefit review officer who will mediate the case and help the parties to hopefully reach a resolution. The benefit review officer will explain the rights of the parties and the procedures necessary to protect those rights. The folks present at the benefit review conference will discuss the facts of the case, review available information in order to evaluate the claim, and delineate the disputed issues. The goal is to mediate and resolve the disputed issues, and that is identified in Texas Labor Code Section 410.021. It's important to note that the benefit review conferences within the state of Texas right now are held remotely by Zoom. We do have an option for in-person benefit review conferences if the need arises. At the benefit review conference, we urge the parties to be ready. And this is necessary because a party or its representative commits an administrative violation if that person attends a dispute resolution proceeding within the division without complete authority or fails to exercise authority to effectuate an agreement or settlement. And that's Texas Labor Code, Section 415.001, Section 2, and 415.002A9. We follow the guidance of the Rudiger case, which is an important case that closed the door to bad faith claims in Texas. And the reason why is because we already have a remedy within the statute, and that is the administrative violation. We require that participants have the ability to evaluate any new information presented at the BRC or the Benefit Review Conference, make a determination based on the new evidence presented, and take action based on the current updated information that they are provided. Also, at the Benefit Review Conference, oftentimes the parties are waiting on a request for a required medical examination report to come back, or they're waiting on causation from a treating doctor on particular conditions. The benefit review officer can enter a scheduling order outlining the goals of the parties to comply with whatever they need to be prepared for a contested case hearing. Now, if you look at approval of a continuance by an administrative law judge at a contested case hearing, a continuance is only granted based on a finding of good cause. And I refer you to Texas Labor Code section 410.155 on continuances. Part A says a written request by a party for a continuance of a contested case hearing to another date must be directed to the division. And B, the division may grant a continuance only if the division determines there is good cause for the continuance. An administrative law judge may consider the parties' efforts to complete their scheduling order commitments. So if that scheduling order tells your administrative law judge that you're working on causation or you're waiting on a required medical examination report, the administrative law judge is going to determine whether you acted timely and if there's good cause to continue a contested case hearing. All right, so let's summarize. You've initiated the dispute with the PLN, or the plain language notice. You've entered the benefit review conference process by attempting to resolve the dispute, filing your DWIC Form 45, exchanging your information, and attending the BRC. During the BRC, or the benefit review conference, the benefit review officer will generate a benefit review conference report. That report establishes the issues to be resolved at the contested case hearing. And that's under Texas Labor Code 410.031 and 410.151B. An issue that was not raised at a benefit review conference or that was not identified in the benefit review conference report may not be considered by an administrative law judge at a contested case hearing unless one of three things or requirements are met. The first is that the parties have to unanimously agree to add the issues, and that's Texas Labor Code 410.151B1 and 28 Texas Administrative Code 142.7B3 and D. The second way to get an issue added is the administrative law judge has to determine that there's good cause to add the issue. And that's Texas Labor Code 410.151B2 and 28 Texas Administrative Code 142.7E. And the third way is the issues were actually litigated by the parties, and this is under Appeals Panel Decision 041286. Now, good luck on getting actually litigating the issues at the contested case hearing, because most administrative law judges run a very tight ship and they do not let folks wander outside the certified issues. The takeaway is that it is crucial to develop the issues as much as possible at the benefit review conference level to avoid problems at the contested case hearing. Do not spring issues on the opposing party at the contested case hearing. If a matter arises in time after a BRC or benefit review conference, notify the opposing party and the administrative law judge as soon as possible of the need to add the issue and the reason for doing so. If you notice a problem with the benefit review conference report, file a response within 20 days of receiving the report. And that's under the guidance of 28 Texas Administrative Code, Section 142.7C.
Jerry Thomas has discussed the parameters of what happens or what to expect at the first level of dispute resolution, which is the benefit review conference. And now we will go on to talk about the contested case hearing, as that is the next step if the parties cannot resolve the dispute at the benefit review conference. So if you are at the contested case hearing stage, the parties and the administrative law judge as well will already have the benefit review conference report that has been issued by the benefit review officer. And the parties and the administrative law judge will also have a scheduling order if one was done in that particular case. And as Jerry Thomas has indicated, the benefit review conference report is to set out the issues to be addressed. And this benefit review conference report also informs of the date, time, and location of the contested case hearing. Benefit review conferences are held remotely, but just keep in mind that contested case hearings are still held in person at field offices. And at the contested case hearing, much like the benefit review conference, parties do need to be prepared to proceed. And the purpose of the contested case hearing is to fully develop the case and inform the administrative law judge of the parameters of the case so that the administrative law judge can make the best possible decision based on all the facts to resolve that benefit dispute. The statutes regarding a contested case hearing start at Texas Labor Code 410.151. A contested case hearing is presided over by an administrative law judge. And per the Texas Labor Code, that administrative law judge must be an attorney that is licensed to practice law in the state of Texas. The contested case hearing is a formal adversarial proceeding that is like a non-jury or a bench trial, and that the parties present evidence and make the arguments to the administrative law judge on the disputed issues. The administrative law judge, at the conclusion of the hearing, will make findings of fact and conclusions of law in a written decision. It's important to note that the parties will not know of the outcome of the case on the day of the contested case hearing. The administrative law judge is given some time, some days, to issue their written decision, and it will be mailed to the parties. As was indicated in the prior slide, the contested case hearing is much like a non-jury trial or a bench trial. And as a component, therefore, the parties are allowed to conduct discovery in the weeks before the contested case hearing. The relevant provisions regarding discovery at the contested case hearing are found at 28 Texas Administrative Code 412.13 and at the Texas Labor Code 410.158 through 410.162. The parties can exchange documentary evidence. The parties, however, would have already exchanged documentary evidence at the benefit review conference level, but the exchange of documentary evidence at the contested case hearing level is a more streamlined exchange. At the contested case hearing level, the parties can also issue interrogatories. That is explained at 28 Texas Administrative Code, and more specifically, there is a set of prescribed questions that are set out at 28 Texas Administrative Code 142.19. Discovery that is allowed at the contested case hearing level also includes witness depositions. Depositions can be taken of healthcare providers in the case. However, only deposition on written questions are allowed. There can be depositions of other witnesses in a case. However, this will only take place if the administrative law judge determines good cause for this. You have already heard the term good cause, and you will hear it a few more times during this presentation. Generally, this means there is a good, reasonable, or compelling reason for the action. So in this case, if there would be a good reason to take a witness deposition, then the administrative judge will allow it. Administrative law judges are given wide latitude in making the determination of what is good cause. Again, like a non-jury trial or a bench trial in conducting discovery before the proceeding or contested case hearing, the division does impose deadlines for discovery. So no later than 15 days after the benefit review conference is held, the parties shall exchange the following information: all medical reports and reports of expert witnesses who will testify at the contested case hearing. They are also to exchange all medical records and any witness statements. Again, like what was shown in the prior slide, these are the most common things that are exchanged. But depending on the issue, there could be other things that need to be exchanged, such as employment records. Again, it just depends on what the issues are in a particular case. So in this slide, and in the prior slide, we are referring to non-expedited exchanges. It's important to keep in mind that there are provisions in the dispute process allowing for an expedited hearing and conducting discovery. In fact, Rule 142.13G states that a notice setting an expedited hearing or a hearing held without a prior benefit review conference shall include time limits for completion of discovery. Rule 140.3 states that allowances are made for certain types of proceedings to be expedited. And usually we see this for issues involving the stay of a designated doctor examination or attorney fee orders. And again, this slide does show that typical discovery can be the identity and location of any witness known to have knowledge of relevant facts, or any photographs or other documents which a party intends to offer into evidence at the contested case hearing. And that is explained at 28 Texas Administrative Code 142.13C1. So we have deadlines when conducting discovery for a contested case hearing. But what happens with discovery or exchange after the deadline? An administrative law judge will base the determination on admissibility of the evidence on whether good cause existed for failure to timely exchange the information. Again, we're seeing that term good cause come up again. Texas Labor Code 410.165 discusses evidence and what the administrative law judge accepts as evidence. The administrative law judge can allow the evidence to come in if it is exchanged after the deadline, or they can simply deny that evidence to come in. The administrative law judge could even allow a record to stay open or to continue a case to afford the opposing side the time to review the late exchange of information. And again, administrative law judges are given wide latitude on determining good cause. And obviously, if the administrative law judge decides that the evidence will not come in, then the administrative law judge cannot consider that evidence in making his or her decision. And this could be a good time to give an example of late evidence coming in and how the administrative law judge might consider whether to allow it or not allow it. An example could be a claimant who is attempting to get medical records from his or her doctor. They've been trying to get those medical records. The doctor's office maybe has been on vacation or something has come up. It's really perhaps a matter that is outside the claimant's control in getting the documents. The judge will look to see if diligent efforts have been made by the party in getting that evidence and in making that decision to whether to allow that evidence to come in or not. Again, the judge has latitude in allowing that evidence to come in, and they obviously can allow it to come in, or they can just simply deny it. If it gets denied, this could possibly be a point of appeal to the appeals panel, and the appeals panel will look to see if the administrative law judge abused his or her discretion regarding that evidence. And again, abusing discretion is a term of art that means whether the judge acted without reference to guiding principles. And another good point to bring up regarding discovery and evidence is that the Texas Rules of Evidence do not strictly apply at hearings before the Division of Workers' Compensation. Continuances at contested case hearings. Jerry Thomas touched upon this a little bit when she was discussing benefit review conferences and scheduling orders and the benefit review conference report. So certainly another important factor to consider about contested case hearings are the possibilities of a continuance. The parties receive a notice informing them of the time and date and place of the hearing, which that is outlined in the benefit review conference report. But what if a party cannot attend at that date and time after all? What if the claimant's attorney is all of a sudden become very ill, or the claimant himself? If you're going to request a continuance before a hearing, the division asks that this request be submitted to the division in writing and as soon as possible. I cannot stress enough that parties should ask for a continuance as soon as they know that one is needed. The division also is going to ask that the party wanting that continuance make the request and reach out to the other party to see if that other party will agree or disagree with the request. That is called conferring with the other side. So the written request for a continuance should have a certificate of conference showing whether the opposing party agrees or disagrees with the request. And again, the rules regarding requesting a continuance are found at 28 Texas Administrative Code 142.10C and Texas Labor Code 410.155B and 28 Texas Administrative Code 142.10B2 both delineate the good cause standard for granting continuances.
All right, so we've gotten through the benefit review conference and the contested case hearing. What comes next in a benefit dispute? Well, after the contested case hearing is held and the record is closed, the administrative law judge will issue a written decision that will contain findings of fact and conclusions of law that resolve the disputed issues in the case. These issues may include the ones like Anna mentioned earlier in the presentation. For example, compensability, disability, extent of the injured employee's compensable injury, maximum medical improvement, or impairment rating, for example. As you can see on this slide, the decision of the administrative law judge is effective and binding on the date signed. And that decision is appealable to the Division of Workers' Compensation Appeals Panel, which is the program area of the agency that I manage. We are a reviewing body currently comprised of 6 appeals judges. To appeal the decision of an administrative law judge, a party shall file a request for appeal with the appeals panel not later than the 15th day after the date on which the decision of the administrative law judge is received by the parties from the Division of Workers' Compensation. The receipt date is based on the deemed receipt provisions found in 28 Texas Administrative Code Section 102.5D. The appealing party is required to serve the appeal to the opposing party or parties on that same date. However, if they do not, or if there is a question of whether proper service has been done, then the appeals panel will serve the appeal to that party or parties. If a party is dissatisfied with the decision of the administrative law judge, they may appeal. A party doesn't necessarily have to file an appeal, and for the most part, the decisions of the administrative law judge are not appealed. Candidly, not all decisions are appealed. Approximately 40% of those decisions are appealed, and approximately 60% are not. Under 28 Texas Administrative Code Section 142.16F, a decision regarding benefits not appealed to the appeals panel, as provided by the Texas Labor Code, becomes final on the 16th day after the date received from the division. So the party responding to the appeal may file its response, which must also be in writing like the appeal, with the appeals panel within 15 days of receipt of the appeal. The respondent is also required to file its response with the other party or parties. If they don't, just like with the appeal, If they don't, or it's unclear whether proper service has been done, the appeals panel will serve that document on the other party or parties. You may ask, what should the appeal or response contain substantively? Well, there are no magic words, but the statute provides some insight. A request for appeal or a response must clearly and concisely rebut or support the decision of the administrative law judge on each issue on which review is sought. And that's in Texas Labor Code section 410.202C. So an appeal should clearly and concisely rebut the administrative law judge's decision, while the response should clearly and concisely support the decision of the administrative law judge. Once the response has been received or the deadline for the response has passed, the appeals panel has 45 days to issue its decision or issue a letter notifying the parties that the decision of the administrative law judge has become final. And I'll discuss that a little bit later. As part of the review process, an appeals judge will review the appeal, response, administrative law judge's decision, and the record of the contested case hearing. Under Texas Labor Code section 410.203B, the appeals panel can only issue written decisions where we are reversing and sending back the decision of the administrative law judge. So in other words, remanding for further action in the case. We may also issue a written decision where we are reversing the decision of the administrative law judge and changing the decision without sending it back to the administrative law judge for further action. And that's known as reversing and rendering the decision of the administrative law judge. We may also write where we are affirming or leaving in place the decision of the administrative law judge for reasons such as the following, which are found in Texas Labor Code section 410.204A-1. Under Texas Labor Code section 410.204A-1, subdivisions 1 and 2, respectively, we may write on an affirmance if the case is a case of first impression or involves a recent change in law. Under subsection A-1, subdivision 3, which is divided further into subdivisions A through D, we may also issue a written affirmance where the case involves errors at the contested case hearing that require correction but do not affect the outcome of the hearing. And these types of errors would include findings of fact for which insufficient evidence exists, incorrect conclusions of law, findings of fact or conclusions of law regarding matters that were not properly before the administrative law judge, or legal errors not otherwise described by this subdivision. Prior to joining the appeals panel, I was an administrative law judge, then known as a hearing officer, for approximately 8 years. Anna and Jerry were also administrative law judges for a number of years before moving into management. All three of us know what it is like to get reversed. And my best advice to the administrative law judge is to know that reversal is a part of the judicial role and experience. It will happen, and you just have to do your best to learn from it. One silver lining from the administrative law judge perspective, perhaps, is that under Texas Labor Code section 410.203C, the appeals panel may not remand a case more than once. In the vast majority of cases, the appeals panel does not issue a written decision, and we issue what is known as a final letter that notifies the parties that the decision of the administrative law judge is now the decision of the appeals panel. The authority for the final letter is found in Texas Labor Code section 410.204C. Before we move on, I wanted to mention that the appeals panel is required by statute, specifically Texas Labor Code section 410.203E, to issue and maintain a precedent manual, which you will find on the Texas Department of Insurance website. If you just Google Texas Appeals Panel Decision Manual, it should take you right to the website. One helpful feature of the manual is that it is organized by dispute issue, and it also includes links to past decisions as well as a list of abbreviations for common terms in the workers' compensation system. And in terms of counting days for appeal purposes, the 15-day appeal and response periods do not count Saturdays, Sundays, or holidays listed in section 662.003 of the Government Code. I would also direct you to 28 Texas Administrative Code section 102.3 for other information on how due dates and time periods are computed in the Texas workers' compensation system. And I should mention that the 45-day deadline over which the appeals panel has jurisdiction over a case, that's 45 straight days. However, if the 45th day lands on a weekend or a non-working day, I should say, then the 45th day falls on the next day that is a working day. So if a party remains unhappy with the outcome of the case after the appeals panel has issued its decision or final letter, then that party may take the case to court. Here you see the provision of the Labor Code dealing with judicial review of an appeals panel decision. Now for something completely different. Appeals on medical necessity do not follow the same track as we discussed earlier with the indemnity disputes, the benefit review conference, contested case hearing, and appeals panel. A medical necessity dispute involves a decision by an independent review organization on whether certain health care is medically necessary for treatment of a compensable injury. The issue in the dispute is typically phrased as follows: is the preponderance of the evidence contrary to the decision of the independent review organization that, for example, whatever the health care at issue is, epidural steroid injection, lumbar discectomy, etc., is or is not health care reasonably required for the compensable injury? The party appealing the independent review organization decision is required to send a copy of its written request for a hearing to all other parties involved in the dispute. And you can see on the slide a reference to the DWC Form 49. The independent review organization is not required to participate in the Division of Workers' Compensation contested case hearing or any appeal. And that's under 28 Texas Administrative Code Section 133.308 S1B. The appeal of the independent review organization decision on medical necessity will go to what is known as a medical contested case hearing with a Division of Workers' Compensation administrative law judge. These are the judges who work for Anna and Jerry. And a benefit review conference is not a prerequisite to a medical contested case hearing. And the appeal of the administrative law judge's decision in a medical necessity case does not go to the appeals panel, it goes to court. Another type of dispute you may be familiar with are medical fee disputes. And these may arise when a request is made for payment or reimbursement of health care in a workers' compensation claim, and that request is approved or denied by the Division of Workers' Compensation Medical Fee Dispute Resolution Program Area. The Medical Fee Dispute Resolution Program Area only decides non-network disputes, and a party may file an appeal of the Medical Fee Dispute Resolution decision by requesting a benefit review conference, which, as Jerry described earlier, that's similar to a mediation. And the Medical Fee Dispute Resolution Program Area may also dismiss a request, or a request can be withdrawn before the dispute is adjudicated. Dismissals are not appealable to a benefit review conference. If the medical fee dispute remains unresolved after the benefit review conference, the parties may agree to arbitration by filing a DWC Form 44 no later than 20 days after the benefit review conference. If arbitration is not agreed to, a party may seek a hearing at the State Office of Administrative Hearings by filing a DWC 49 with the division's chief clerk of proceedings no later than 20 days after the benefit review conference. So there is no hearing before a DWC administrative law judge, and there is no review of these cases by the appeals panel.
All right, welcome back to the Q&A portion of our webinar. Panelists, if you'll please turn on your cameras and mics. Thank you. Joining us to take your questions are our presenters. Jennifer Hopens, Deputy Commissioner for the Appeals Panel, Anna Thornton, Director of Hearings for the Southern and Eastern Regions, and Jerry Thomas, Director of Hearings for the Northern and Western Regions. So before we start shooting questions at them, I have just a couple of ground rules that I need to pass along. Any questions about a specific company we're not going to address in this open forum, and we can't discuss any details of any kind of pending disputes. You can always email us those questions The email address is dwcinsuredqa@tdi.texas.gov, and you'll find it right now in the chat, I believe. And we'll repeat it again when we wrap up today. So please use the Q&A feature in Zoom to send us your questions, and any that we don't get to today, you can always reach out to us via email and we'll try to get you that answer. All right, Jennifer, Anna, and Jerry, you ready for some questions?
Yes, sir.
Sure.
Excellent. All right, so here's the first one up. Before filing a request for a benefit review conference, how much effort do the parties really need to make to resolve the dispute before they get there beforehand?
They should at least speak to one another and try to get on a level playing field. Typically, what we see are phone notes or quick emails between the parties, and they file that with their DWIC 45, just showing us that they've made some attempt to resolve the dispute before they request a dispute resolution through the division.
Okay, so just make some effort there and document it. Next up, what happens if somebody is going to need an interpreter for either a benefit review conference or one of the other steps in the process?
I'll handle the BRCs, and Anna, you want to discuss this?
Sure, I'll go ahead and I'll just go ahead and discuss both. At the benefit review conference level, we do not provide an interpreter. Typically, the claimant who typically does need the interpreter, they will bring maybe a relative or a friend, and that's allowed. Then if the matter isn't resolved at the benefit review conference and it goes on to a contested case hearing, certainly the parties can request, we would ask that it be requested beforehand, the need for the interpreter. The division will provide the interpreter for the contested case hearing at no charge. But again, I would say what's key is asking for that with plenty of notice so we can get that interpreter ready for the proceeding. Ideally, they would ask for that interpreter at the benefit review conference.
And
Yeah.
quickly at the BRC level, we also have a language line that can be utilized, and we do have a few bilingual BROs or benefit review officers.
Perfect. Thank you both. All right, next up, does the benefit review officer work for a DWC?
Yes, they are licensed benefit review officers. They are trained in mediation, and they are employed by the division.
Perfect. Simple. Next up, this is a question for our attorneys, all of you. What is the percentage of resolving these issues at the BRC level versus the CCH level? Do you have a percentage or a feel about that?
Actually, I looked into that right before the presentation, ironically. About 17% of cases, in other words, at the point where the parties have filed a DWIC 45 and it goes on to the benefit review conference, about 17% of the cases are completely resolved at the benefit review conference. Then going on to the contested case hearing, we're seeing approximately 3% of those that go on where the parties have submitted what we call the DWIC 24, which is an agreement of all the issues, or the parties show up at the contested case hearing and inform the hearing office, the administrative law judge, that they've reached an agreement. That's about 4% for what we call the agreed decisions. So 4% for those, and about 3% for the submission of the DWIC 24 form before the contested case hearing.
Very good. Next question up. Do you need the patient to attend the BRC level hearing, or can it just be the healthcare provider and the insurance carriers?
The injured worker should attend. I mean, there's a lot on the line for an injured worker if just a healthcare provider and an insurance carrier show up. So we will send them notice and find a way to get a hold of the injured employee. Do they always show up in that case? No, but we would like them to.
Ideally, we'd want them to be there.
Yes.
Next up, is there any appeal panel decision cases that we can look at? Is there a dispute case bank that can be reviewed?
Yes, we have on the website, I mentioned in the presentation, we do have a appeals panel decision manual that contains links to a number of past appeals panel decisions. We also have separate from that, we have redacted versions of our appeals panel decisions. Many go back to the early 1990s, and these are located on the website at www.tdI.texas.gov/WC/admin decisions.html. Or you can just Google Texas Administrative Law Judge, Texas Appeals Panel decisions, and it should come up. And it's searchable.
Great. Thanks, Jennifer. Next up, this is sort of similar, but do parties have to attend the contested case and hearing? You mentioned that there were some Zoom availabilities or maybe even abilities to dial in on the phone. Do they have to attend the contested case hearing in person?
That's a good question. Parties do have to attend a contested case hearing in person unless they are out of state. We do not have the capacity to have Zoom contested case hearings. That's not even in the rules or the statutes. The statutes do allow for Zoom benefit review conferences, and that's actually a recent development that happened right after COVID. But parties that are claimants rather that are out of state can participate, but a motion does have to be filed by the claimant or his or her attorney requesting to appear by telephone for the contested case hearing. And all they simply need to state is that they are out of state. It would be difficult to come and attend the proceeding in person. I would say for contested case hearings, the insurance carriers always have an attorney or representative that's nearby, so they always appear in person.
Excellent. Thank you. Next up, regarding the plain language notice, the PLN1s, if there's a PLN1 for intoxication sent to the provider by the insurance carrier, can the provider just accept that PLN1 and waive requesting a BRC hearing or bill the patient?
Absolutely not. That's a no-no.
No. Excellent. All right. Here's one about continuances. You mentioned continuances in the presentation. Are those always granted for the requesting side?
Regarding a contested case hearing, I would say not necessarily. Just because a party's requested that doesn't mean it's going to be granted. The standard that the administrative law judge is going to look for is good cause. And once again, I've even seen some scenarios as an administrative law judge or even as a director, judges telling me where both parties agree to have a continuance, but if the requesting side has not met the good cause standard, it's not going to be granted.
Have to have a good reason there.
Right.
Next up, if we go through the BRC process and the CCH process, but we fail to resolve the issue, what happens? What do we do after that?
Well, you can file an appeal to the appeals panel. I discussed in the presentation the way to go about doing that and the deadlines. And so if you're still unhappy at the conclusion of the contested case hearing with the administrative law judge's decision, and it is an indemnity dispute, it's not a medical necessity dispute or a medical fee dispute like we discussed, then that should be appealable to the appeals panel.
All right, thank you very much. Is it possible for me to bring my own court reporter to a BRC or contested case hearing?
I'll go ahead and answer that. At benefit review conferences, we do not allow court reporters because we do not allow transcripts at benefit review conferences. The goal or the purpose at the benefit review conference is to have it be like a mediation, a little bit more relaxed and informal. Now, at a contested case hearing, yes, a party can bring a court reporter. They need to notify the administrative law judge that they would like to have a court reporter. The party does have to pay for it. The division does not provide the court reporter. So I would say in my experience, what I've observed, about 15% of the time, insurance carriers representatives will bring a court reporter. And I'd say maybe about 5% of the time, the claimant side will bring a court reporter.
Okay, thank you, Anna.
Mm-hmm.
Next up, how long does the benefit review conference generally take? Is it the same amount of time for a contested case hearing?
No, a benefit review conference is slotted for 45 minutes. It can be less, but it usually lasts approximately 45 minutes. Ani, you want to take the CCHs?
Yes, contested case hearings, we allot 2 hours for contested case hearings. Contested case hearings can last maybe as little as 15 to 20 minutes. Some go on for quite a bit longer. With that in mind, it's very important, perhaps if the parties are going to recognize that a hearing might go longer than 2 hours, to let the benefit review officer know when they are going to send it up and set it for a contested case hearing, to notify the docketing staff that it might be a case that might go on for more than 2 hours. That way we can have the appropriate time set for the hearing.
If there's some unusual complexity or length to the
Exactly.
decision. Here's another one about time. When a benefit review hearing is requested for continuance and that's granted, how many times after that can either party then request another continuance?
The first one's granted automatically if it's timely submitted. After that, it's based on good cause as well. It can't go on forever because the cases have to be moving. I mean, we have to progress each case, and it's going to be case specific. So that's a difficult one to answer. It depends on the circumstances and the need for the continuance. If it's agreed to, if it's not agreed to, if it's just availability. I mean, they're by Zoom, so probably need to go ahead and go forward.
And it's always best to make those requests for continuance as early in the process as possible. That way, the benefit review officer or the administrative law judge is able to fill that slot with another case, so it's not wasted.
Very good. Thank you so much. Next up, is a medical provider the only party that can request a medical fee dispute?
That's very interesting. We had the slide on medical fee dispute resolution, and that's really a separate program area from hearings or the appeals panel. So that might be a good one. I don't want to give a wrong answer, so we'll take that to the proper authorities and return and let you know.
Yep. And they can always email additional questions if we don't
Right.
answer it here.
Very good question, though.
Yeah, it's a good question. Next up, what percentage of claims are overturned at the appeal level?
Oh, that's a great question.
Approximately.
We write roughly on, I would say, between maybe 3 and 5% of the appeals that come in. So as I said in the presentation, most of the time we let the case go final by issuing our final letter. So, I mean, yeah, and as I noted in the presentation, we're only limited to writing on certain cases, and so if there's not reversible error, then chances are the case will go final, unless we need to write an affirmance to, based on the reasons given in the presentation.
It's got to end at some point. Let's see here. What do we have left? Can you ask for a transcript of a hearing procedure?
If it's a contested case hearing and it is your hearing, you can write to the division or call the division and ask for the recording of it. There is a fee, but the recording can be provided. You just need to give them the DWIC claim number.
Okay, sounds good. And here's another one. Is there any chance that we'll go back to in-person BRCs like the way they were before? Not a fan of the Zooms. I know the option is available, but wondering if Zoom is going to remain kind of the permanent default.
It should be permanent. I mean, there was an option for everybody to weigh in during the legislative session. This is what was passed, and we're good with it. If there's a need for an in-person BRC, we take them on a case-by-case basis.
Yeah, there's some efficiency that to be had by telecommuting that. All right, I think we're going to have to wrap it up there because we're out of time, just a few more seconds before 3 o'clock. So sorry if we didn't get to your question. They're still coming in. But if you think of something later that you'd like addressed, or we didn't get your question, please send it to the email we mentioned earlier, DWC Insure Ed Q&A at tdi.texas.gov, and we'll try to get you an answer if we can. Well, that's it for today. Thanks so much for joining us. Have a great rest of your day, and we'll see you at the next TDI webinar.